Friends, the much awaited judgment of the Hon'ble Apex Court in the case of Safari Retreats is published now. This judgment was much awaited because it was to be decided whether goods or services used for the construction of immovable property is allowed for the purpose of input tax credit under GST or not. In this case, Hon'ble Apex Court has held that under section 17 subsection 5 clause D, the input tax credit for goods or services used for the purpose of construction of immovable property is not allowed as input tax credit, subject to two exceptions. First, where the goods or services are used for the purpose of construction of immovable property other than plant or machinery. Number 2, where the immovable property is not used for own account. So, coming to the first exception, what is the definition of this plant or machinery which has been excluded for the purpose of blocking of input tax credit? Is plant or machinery the same as plant and machinery as described in and explained in the explanation to section 17? The Hon'ble Apex Court has held no. The explanation provides for plant and machinery. However, the words used in 17(5)(d) is plant or machinery. So, what is the definition of plant or machinery? For this, the Honorable Supreme Court has relied on various judgments and has distinguished the judgment in the case of Anand Theatres, which has provided that a building cannot be a plant for the purpose of hotels or theatres. The Hon'ble Apex Court has held that for the purpose of renting or leasing out of malls or warehouses, building can be considered as plant subject to functionality test. Now, what is this functionality test? In case the building has been constructed with such technical specifications so as to help the building being leased or rented out as provided under clause 2 or clause 5 of schedule 2 of the CGST Act, then it can be considered as a plant. Hence, subject to functionality test, a building which is constructed for renting or leasing out or tenancy in the nature of malls or warehouses can be considered as a plant, and each case has to be weighed on this basis. Second is, the building should not be used for own account. That is, the building should not be used for personal purposes, or the building should not be used only as for the purpose of carrying out of a business or profession. However, in case the building is used for the purpose of renting or tenancy or letting out or leasing out, then it cannot be said that building is used for own purpose. Therefore, for the purpose of blocking of input tax credit under 17(5)(d), where on the basis of functionality test, goods or services are used for the purpose of construction of a building which was built with such technical specifications so as to help it to rent, lease or let out for the purpose of malls or warehouses, input tax credit can be taken. The second issue was whether section 17(5)(c) or D, blocking of input tax credited for goods or services used for the purpose of works contract or construction is ultra vires the constitution or not. The Hon'ble Apex Court, citing VKC footsteps, has held that in taxation statutes, mere discrimination would not hold a provision as ultra vires. A provision can be held ultra vires only if it treats unequals as equals or equals as unequals. In the GST Act, immovable properties are considered to be as a class in themselves, and therefore the blockage of input tax credit for works contract or construction of immovable properties cannot be treated as ultra vires, as it does not fall in this ambit. So friends, now all such cases of blocking or disallowance of input tax credit were capitalized for goods or services used in construction of immovable property, being malls, warehouses, etc., has to be retested with functionality test, and accordingly ITC can be allowed or disallowed. Thank you very much for listening. Please do like, share and subscribe to this channel. Thank you very much. Stay tuned.